Hello, my name is Greg Kish. I'm an attorney who practices probate and estate planning law in the Grand Traverse and Leelanau County areas. I'm here today to address three additional issues with regard to conservatorships. The first is the compensation of the conservator. Michigan law says that conservators are entitled to reasonable compensation for the services that they provide to the protected individual, but the law doesn't specifically define what reasonable compensation means. Through court cases and practices, we know that reasonable compensation typically means an hourly fee that takes into account the complexity of the estate, the specialized training that the conservator may have and may be using for the tasks for the estate's benefit, if any, as well as the results that the conservator obtains. In Northwest Lower Michigan, I've seen conservatorship rates range from $0 for people who volunteer their time and services, which is perfectly acceptable. There's no requirement that conservators charge a fee, up to $90 or $100 an hour for professional conservators other than corporate trustees. I find that in my practice, most conservatorship estates that involve conservators who are individuals um, have those individuals charging between $15 and $45 an hour for their services. But again, it's a case by case analysis. There is no requirement that the conservator obtain court approval before paying the fee. However, I generally advise my clients that it's a good idea, if it's workable, to wait until the court approves the accounting or approves the fee before paying it. Now, it's absolutely critical that a conservator seeking compensation from the estate keeps very good records to support the time spent and the tasks performed. I recommend that right from the beginning, conservators get a notebook and keep a log of the date, the amount of time spent for the protected individual's benefit, and a description of the tasks performed, along with a notation of any travel or other expenses that relate to the estate. This detail is absolutely necessary to include as an attachment to the conservatorship accounting and or when making a request to the court for payment of the conservator's compensation. The next topic I'll talk about is a surety bond. Now, a surety bond is a contract between an insurance company or surety company and the conservator. It's a contract that where the company will pay a benefit to the conservatorship estate if the estate experiences a loss because of some mismanagement by the conservator. It's an extra layer of protection for the protected individual. You will know whether the court has ordered a surety bond in your case by looking at the court order appointing a conservator. The court order will say whether or not a bond is required. Typically, if there is cash in the estate or other assets that are readily convertible to cash above a certain amount, the judge must order a surety bond unless one of the exceptions applies. That amount is $25,000 in 2022 and is adjusted annually for inflation. One of the exceptions that's fairly common is that instead of ordering a surety bond, the judge may order that the conservator place liquid funds in a restricted account at a financial institution for another layer of protection. In the event a bond is required, that bond can be obtained from a surety company or insurance company, and an attorney or perhaps the probate court office can help the conservator locate an appropriate company to issue the bond. There is a cost for a surety bond, and that cost is payable from the protected individual's estate. It's not the responsibility of the conservator individually. The probate court will require proof that the bond has been issued before the court will issue letters of conservatorship. The last topic I'll cover today is important steps to take when a conservatorship ends. Conservatorships typically end for one of two reasons. One is that the protected individual has regained the capacity to effectively manage his or her own financial affairs, and the second is the death of the protected individual. If the protected individual dies, the conservator must notify the probate court within 14 days and deliver to the probate court the protected individual's original will if the conservator has it in his or her possession. It's also good for the conservator to notify whoever has been nominated in that will as the personal representative. It's also important that the conservator stop spending money from the protected individual's estate, which means stop paying bills and just retain and secure the estate for delivery to the personal representative. If 42 days passes after the protected individual's death and no personal representative has been appointed by the court and no petition is pending for a personal representative to be appointed, the conservator can ask the court for the powers of a personal representative so that the conservator can then take steps to wind up the estate. If the protected person did not pass away but instead regained capacity, then the conservator's role is to gather the estate's assets and deliver them back to the protected individual. That process would involve an order of the probate court that the person is no longer subject to a conservatorship. In either case, whether it's the death of the protected person or in regaining of capacity, the conservator will need to prepare a final account and file that account with the probate court. The account should cover the time period between the end of the last account or the inventory, if this is the first account, and the date of the protected individual's death or date that the court ordered the conservatorship to end. This should be filed, the account should be filed with the probate court within 56 days of a protected individual's death, along with a petition to approve the account. And the court would then issue an order approving the accounting and discharging the conservator.